So hello, we were doing the course for EPFO here and we were doing labor laws, and here we'll complete the entire labor laws using these 400 questions. So we have already completed 50 questions. Now let's start with 51st. Which of the following bodies hears appeals against orders of the EPF Appellate Tribunal or its successor? Supreme Court directly, High Court via writ jurisdiction, or Supreme Court on special leave petition? Labor Court, Local Service Court. So the answer is High Court via writ jurisdiction, or Supreme Court on special leave petition. The explanation: appeals from tribunals generally lie to the High Court on writ jurisdiction and further to the Supreme Court by special leave. Specific appellate routes depend on statutory provisions and judicial recourse. Now here you tell me one thing. writ jurisdiction के केस में किसका जो पावर ऑफ स्पेक्ट्रम है वो बड़ा है? इन केस ऑफ हाई कोर्ट और सुप्रीम कोर्ट रिट किस किस चीज़ पे इशू कर सकता है? जो पूरा स्पेक्ट्रम है सुप्रीम कोर्ट का इज़ लार्जर और हाई कोर्ट. देन अंडर द कोड ऑन सोशल सिक्योरिटी विच ऑफ दी सोर्सेज इज एनविसेज्ड टू फाइनेंस सोशल सिक्योरिटी फॉर गिग प्लेटफॉर्म वर्कर्स? एम्प्लॉयर contribution from traditional employers only, contribution by aggregators, central state budget allocations, cess and workers contribution, international loans only, donations from NGOs only. So the answer is 2, that is contribution by aggregators, central state budget allocations, cess and workers contribution. So the code contemplates multi-source financing for gig platform workers. Now who are gig platform workers? You must be aware, we have done this already. जो आप ऑर्डर करते हो using Blinkit, your Zomato and so on. So the people who work here, come to your place, deliver your stuff, all of these are gig workers. Social security including aggregator contributions, government funding and workers contribution, possibly via cess mechanisms. Then under IT Act, that is Industrial Dispute Act. Industrial Dispute Act. An unfair labor practice by workmen includes ghirav and violence to form employer acceptance, filing grievances in writing, submitting to conciliation, participating in bipartite committees. So correct answer is first, that is ghirav and violence to force employer acceptance. So coercive actions like ghirav, violence, intimidation to enforce demands are unfair practices under schedules and may attract sanctions. Then under the Maternity Benefit Act, which of the following is a statutory right for a pregnant woman? Right to work overtime during maternity leave, right to maternity leave of specified duration and nursing breaks after return to work, right to termination during pregnancy, or right to unpaid leave only. So the correct answer is 2, that is right to maternity leave of specified duration and nursing breaks after return to work. The Act provides maternity leave entitlements, that is 26 weeks for eligible employees, and mandated nursing breaks upon return with protection from termination during pregnancy. Then which is the correct threshold for requiring an internal complaints committee under POSH for every establishment? 5 employees, 10, 20 or 50? So the answer is 10. PYQ पहले आया हुआ है ये, ठीक है, 10 employees. So the POSH Act requires an ICC, that is Internal Complaints Committee, every workplace having 10 or more employees. So जहाँ पे भी जो employees हैं are more than or equal to 10, वहाँ पे क्या होगा? ICC, that is Internal Complaints Committee, ensuring internal redressal capacity for sexual harassment complaints. Then the priority of relief in EPF ED allied death cases typically puts which obligation first? Employer's discretion in payment, EPFO's duty to ensure rightful nominee receives benefits, coordinate with death claims and surveyor pension rules. Delayed payment until litigation ends, local municipality decides. So the correct answer is second, that is EPFO's duty to ensure rightful nominee receives benefits, coordinate with death claims and surveyor pensions rules. So EPFO is mandated to administer death benefits and ensure rightful claimants receive EDLI and pension benefits subject to verification and statutory rules. Under the Industrial Relation Code, how is strike treated differently compared to previous law. So no change, identical treatment, greater procedural requirements and clarified timelines for notices, certain restrictions for public utility service, strikes are fully banned, strikes are now treated as criminal offense. So the correct answer is 2. That is greater procedural requirements and clarified timelines for notices, certain restrictions for public utility service. Then the IR code, that is Industrial Relation Code, introduces clearer procedural requirements for notice and restrictions for strikes, lockouts, especially in public utility service to ensure industrial stability. Under the ESI Act, sickness benefit is normally payable at which rate of average daily wages? 50, 60, 70 or 100%. So the answer is 2, 60%. Sickness benefit under ESI is paid at 60% of the insured person's average daily wages for certified period, subject to terms and duration limit under ESIC rules. A dismissal without conducting a fair domestic inquiry is valid and final, likely to be set aside by labor courts for violating natural justice unless employer shows justification by independent evidence, encouraged in law, automatically converted to resignation. So answer is 2, that is likely to be set aside by labor courts for violating natural justice unless employer shows justification by independent evidence. So courts insist on compliance with principle of natural justice, notice of charges, opportunity to be heard, a grossly unfair inquiry or no inquiry can render dismissal illegal unless employer justifies action. Under CLRA, now what is it? We have done this in the previous video. You tell me the full form. Under CLRA, the registration of principal employer and license of contractor must be renewed. Never as per the terms of the license registration and subject to statutory renewal conditions, that is periodic, only once in a lifetime, only when company changes name. So the answer is periodic as per the terms of license registration and subject to statutory renewal conditions. Then registration and licenses are time bound and must be renewed per statutory rules. Failure to renew can render contract labor engagement illegal. Under the Payment of Wages Act, the employer must pay wages to employees annually, monthly within 7 days of wage period, or as specified by law, state whenever convenient, twice a year. So the answer is 2, that is monthly within 7 days of wage period as per or as specified by law or state. The Act requires timely payment of wages, generally within 7 days of the end of wage period. Those states can specify different timelines within statutory bonds. So new updates related to labor laws are already being updated on the Telegram. The name is EDUASTRA. You can have a look at the channel. You will find a lot of useful PDFs on the same channel related to a lot of different topics, as well as a lot of topics which we will not be able to do here. I'll provide you with the PDF on the Telegram. And even if you're preparing for some other exam, then also stay tuned. You will be provided with a lot of notes. Under the Sexual Harassment of Women at Workplace, POSH rules, which of the following is not an interim relief an employer may provide? Transfer of complainant or respondent, grant of leave to complainant up to 3 months with pay, monetary settlement without inquiry at as first step, change in reporting structure. So monetary settlement without inquiry as first step is what you cannot do. Okay, so monetary settlement without an inquiry is not permissible as the initial resolution, interim reliefs like transfer, leave, change in reporting are allowed to protect the complainant. An establishment covered under the Factories Act must maintain which of the following registers? Muster roll, annual return, accident register, all of the above. So the answer is 4, all of the above, that is muster roll, annual return, accident register. Factories must maintain multiple statutory records including muster roll under Factories Act, including muster rolls, annual returns, accident register and other registers for safety, wage and attendance as required under Factories Act. Under the Industrial Dispute Act, which authority can refer a dispute to adjudication for settlement? Board of Conciliation only appropriate government for public interest employer only or registrar of companies. So appropriate government for public interest. The appropriate government has powers to refer disputes to adjudication when it is in public interest or when conciliation fails, among other circumstances. Then under the EPF and MP Act 1952, wages for contribution purposes is subject to interpretation, which judicial test is commonly applied to determine inclusion of an allowance, whether allowance is discretionary, whether allowance is universally, ordinarily, and necessarily paid to employees performing duties of that class, whether employer labels it as non-PFable, whether it is paid annually. So whether allowance is universally, ordinarily, and necessarily paid to employees performing duties to that class. So courts apply the universally, ordinarily, and necessarily test to determine whether a particular allowance should form part of wages for PF contributions. Under the Gratuity Act, on termination due to superannuation, gratuity is not payable, payable subject to qualifying service, payable only if employee resigns, payable only on retrenchment. So the answer is payable subject to qualifying service. So gratuity is payable on superannuation retirement, provided the employee satisfies the qualifying service requirement, generally 5 years unless exception applies. Which of the following is a valid feature of Code on Wages? It merges multiple wages laws and creates a unified definition of wages. It abolishes the Minimum Wages Act entirely. It makes wages subject to market force only. It exempts all allowances from being considered wages. So correct answer is first, that is it merges multiple wage laws and creates a unified definition of wages. The Code on Wages consolidates payment on wages, minimum wages and bonus acts, aiming for uniformity especially in defining wages and administering minimum wages and bonus. Under industrial dispute jurisprudence, the Supreme Court in Bangalore water supply clarified the test for workman status only, industrial dominant nature test, minimum wages, PF coverage. So the answer is 2, industrial dominant nature test. The Bangalore water supply case articulated the dominant nature test to determine whether an entity constitutes an industry under the Industrial Dispute Act, broadening the scope beyond more profit making. Now there is one more thing. Polity and governance is also a very important topic for this exam. So please have a look at the important cases, and some very easy and factual questions are also there, like whether preamble is a part of the constitution or not. Okay, so like this. Now few cases which are related to this, like Berubari Union, then Keshwanand Bharat, then LIC versus Government of India. So I'm just telling you briefly, बेरूबाई यूनियन में क्या बोला था कि प्रियम्बल इज नॉट अ पार्ट ऑफ द कॉन्स्टिट्यूशन. देन केशवानंद भारती में बोला कि प्रियम्बल इज अ पार्ट ऑफ द कॉन्स्टिट्यूशन. देन एलआईसी केस में क्या बोला, that preamble is an integral part of the constitution. So please keep this in mind as well. Then under the ESI scheme, maternity benefit duration covered is generally 12 weeks only, 26 week aligned with Maternity Benefit Act for insured women, subject to conditions, no coverage for maternity, 52 weeks. So the answer is 2, that is 26 weeks aligned with Maternity Benefit Act for insured women, subject to conditions. ESI provides maternity benefit consistent with statutory provisions where insured women can avail paid maternity benefits as per scheme rules and Maternity Benefit Act entitlements. Under the workman compensation principle now subsumed in labor law frameworks, compensation for death is usually calculated as flat 1 lakh, a multiple of monthly wages determined by statute, formula depending on age and wages, up to employer discretion, not payable. So the answer is 2, a multiple of monthly wage determined by statute, formula depending on age and wages. Compensation for death is formula based, a multiplier times monthly wages, subject to maximum limits and statutory schedules and not discretionary. Which of these is not ordinarily considered an unfair labor practice by employers? Interfering with trade union activities, threatening dismissal for union memberships, refusing to implement a lawful bipartite settlement, Providing statutory benefits as required by law. So the answer is 4, that is providing statutory benefits as required by law. Providing statutory benefits is a lawful obligation, not an unfair labor practice. The others are classic example of unfair labor practices attracting penalties. Then under the Industrial Relation Code, which mechanism is emphasized to prevent disputes at establishment level? Immediate referral to tribunal, bipartite mechanisms such as works committees, grievance cells and joint councils, complete reliance on police action, mandatory closure of establishments with disputes. So the answer is bipartite mechanisms such as works committee, grievance cell and joint councils. The code emphasizes local dispute prevention through bipartite, tripartite mechanisms, works committees, grievances, redressal cells to resolve issues at source. Under the Contract Labour Act, which of these is statutorily required to be displayed at the workplace? Company profit statement, name and address of licensing authority, license number and contractor's detail, personal data of all employees publicly. None of the above. So the answer is name and address of licensing authority, license number and contractor's details. The CLRA Act and rules require display of license and registration particulars to ensure transparency about contractor arrangements and compliance. Then what is CLRA? So this is Contract Labor Regulation and Abolition Act. ठीक है, Contract Labor Regulation and Abolition Act. Then under the EPF scheme, a member's UAN, that is Universal Account Number, is optional, mandatory for portability and consolidation of accounts across employments, assigned only at retirement, applicable only to government employees. So the answer is 2, mandatory for portability and consolidation of accounts across employments. Then Universal Account Number is a unique identifier consolidating multiple EPF member accounts across employments, enabling portability and easier claim processing. The labor codes envisage a single registration and license for establishments. This is intended to increase multiplicity of forms, simplify compliance by replacing multiple registrations under different laws, reduce employer obligation entirely, replace social security institutions. So simplify compliance by replacing multiple registrations under different laws. Single registration consolidates multiple registrations and returns to ease compliance, though detailed operationalization depends on rules and state adoption. Then in labor jurisprudence, the test to decide whether contractor's worker is actually a servant of the principal employer focuses on economic dependence, control and integration into the employer's operation. The name in the employment contract only, whether the contractor supplies tool or whether the worker is paid in cash. So this is the question for you. You tell me what is the correct answer. In the next we'll start with this question and then we'll move ahead. Again, if you need help with any other exam, do let me know. We'll be doing here EPFO as well as NABARD CV and important lectures for other exams as well. PDFs of the same will be available on the Telegram. If you need the link, do let me know. I'll provide you with the link. So that's it in this. All the very best and thank you.